Thank you, Madam Chair. I want to ask at the outset the question of, can't we walk and chew gum at the same time? Can't we protect the health of the mother and also the baby at the same time? It seems to me that as a civilization that can put human beings in space, along with satellites, and achieve all the other accomplishments that we have, ought to be able at least to establish those things as dual objectives that can exist in the same universe. Now, it's important to remember here that public opinion polling shows that policies prohibiting late-term abortions are widely supported by the American people. A recent Marist poll, in fact, shows that 80% of Americans favor limiting abortion after the first trimester. The policies contained in Senator Graham's bill and in Senator Sass's bill are not controversial, not at all, for the vast majority of Americans. The Born Alive Infants Protection Act of 2002 established that children born following a botched abortion are in fact legal persons for purposes of federal law. It passed the United States Senate at the time by unanimous consent. Not one senator voted against it. Senator Sass's bill is a logical complement to that legislation. It just sort of completes the same thought, but by saying that babies who survive abortions and after having done so are themselves legally recognized as persons by existing federal law should get the same kind of care that other babies get. Yet stunningly, 44 United States senators voted against this basic protection just in the last few weeks. Simply put, it's stunning to consider that one of our nation's two major political parties, a party that itself once said that abortion should be safe, legal, and rare, now almost uniformly opposes even minimal protections for babies outside the womb. Babies who, like Ms. Oden, have survived an attempted abortion. The governor of Virginia recently stated, to the shock and horror of countless Americans, that under a proposed pro-choice law, in the context of a proposed pro-choice law, he said that if a baby survives an abortion, quote, the infant would be delivered and then a discussion would ensue between the physicians and the mother. This is an extremist position regarding abortion, one that's wildly out of step with the American people. Now, the Constitution, importantly, says absolutely nothing about abortion. And the legal traditions in place in this country routinely allowed for restrictions on this practice. The great liberal law professor, John Hart Ely, who was himself pro-choice, I would add, famously wrote that Roe versus Wade, quote, is not constitutional law and gives almost no sense of an obligation to try to be, close quote. In other words, this amounts to constitutional law by judicial fiat, no more and no less. So, Ms. Foster, I'd like to start with you. Where in the text of the Constitution does the Constitution place any significance on this distinction that we've talked about today between pre-viability and post-viability fetuses? A distinction that the Supreme Court has rested so heavily in its reasoning. Where does that come from? What text supports that in the Constitution?
Well, it's simply not in there. I would also point out, you're talking about the polling of Americans, and Americans United for Life recently partnered with YouGov, and we found that 66% even of self-described pro-choice Americans agree that when it comes to those post-viability abortions, that's something that we can all agree on. As a post-abortive woman myself, I know that what the Supreme Court said was true, that so many American women do come to regret that choice we made to terminate a life that we once carried and nurtured within our bodies. And so women need this information. Women need the information that we aren't getting from clinics, and so I would simply say that that when it comes to that distinction, both pre and post viability abortion restrictions are perfectly constitutional according to what our own U.S. Supreme Court has said.
So, in other words, this is a doctrine created by a court. That chose somewhat arbitrarily, at least arbitrarily in the sense that it's not mandated by the Constitution, that you draw a distinction based on pre and post viability as opposed to another factor like, say, pre and post pain capability. Is that right?
That's absolutely correct, and we've seen that the line change over the years through the different Supreme Court cases that the court has considered. We've seen that that standard and that line change, and as we make medical progress, as we learn more about the facts about abortion and about abortion law, we see more and more American people coming to be pro-life, to oppose, especially these brutal, barbaric third trimester and later second trimester abortions. This is really a truly bipartisan issue, except with the leadership of one of our political parties.
Thank you, Madam Chair.